Turkish minority of Western Thrace and the Turkish community in the Dodecanese. The Turkish minority of Western Thrace. The Turkish-Muslim population living in Greece, with the exception of the Turkish population in Western Thrace, and the Greek Orthodox population living in Turkey, with the exception of those in Istanbul, Gökçeada, and Bozcaada, were subject to a population exchange, in line with the relevant agreements to which Turkey and Greece are parties. Currently, about 150,000 ethnic Turks live in Western Thrace, Greece. This population constitutes the Turkish minority of Western Thrace, whose status was established by the Lausanne Peace Treaty of 1923 and whose rights were guaranteed by several bilateral and multilateral agreements. Articles from 37 to 44 of the Lausanne Peace Treaty cover the rights of non-Muslim minorities in Turkey, while Article 45 states that the rights conferred by the provisions of the present section on the non-Muslim minorities of Turkey will be similarly conferred by Greece on the Muslim minority in her territory. The members of the Turkish minority of Western Thrace, however, cannot enjoy their minority rights. Main problems faced by the Turkish minority are the following. Denial of ethnic identity. Greece denies the ethnic identity of the Turkish minority of Western Thrace on the grounds that the Lausanne Peace Treaty refers to Muslim minority. However, convention and protocol signed between Turkey and Greece on the exchange of Turkish and Greek populations of 1923 refer explicitly to Turks and Greeks. Moreover, the AWE, those who have not been subject to the population exchange, document given to the members of the Turkish and Greek minority respectively in Greece and Turkey by the Turkish-Greek Joint Commission, which states that they are AWE, also explicitly refers to Turks and Greeks, not Muslims and non-Muslims. Furthermore, it was Greece itself who made it compulsory for the minority to be called as Turks back in the 1950s. Greece had even issued decrees in the 1950s to this end. The minority schools were also called as the Turkish schools. The legislation No. 3065/1954 clearly referred to the minority schools as the Turkish schools. However, the Greek authorities changed their policy on political grounds and thus started calling the minority as the Muslim minority. Greece also started to ban the associations bearing the adjective Turk/Turkish in their titles. The minority brought the cases before the European Court of Human Rights, ECTHR. The ECTHR passed 3 judgments that the ban on the Turkish Muslim minority NGOs bearing the adjectives Turkish/minority in their titles is discriminatory and in contradiction with the freedom of association of the European Convention on Human Rights, ECTHR. Article 11 of the ECTHR. In one case, it was ruled that Greece violated the right to a fair trial. Article 6 of the ECTHR as well. However, Greece does not implement these verdicts. Due to the non-implementation of the ECTHR rulings, the issue is still on the agenda of the Committee of the Ministers of the Council of Europe, which supervises the execution of judgments of the ECTHR. Problems in the field of education. The minority's right to education in mother tongue is safeguarded by the Lausanne Peace Treaty. However, the minority faces several problems in the field of education. Some new practices in particular towards the minority constitute a step backwards. Lack of bilingual kindergartens. Kindergartens are part of the compulsory education for the minority as of 2011 to 2012 school year in Greece. However, the minority's request for opening bilingual minority kindergartens has not been met, with applications pending from 2011. Closing down and merging minority elementary schools. Under a new legislation that took effect in 2011, minority elementary schools have either been closed down or merged with others, 60 in total. This legislation has not paved the way for the opening of new minority elementary schools in the places which are in dire need of a minority school. Lack of adequate number of minority secondary high schools. The number of minority secondary high schools is inadequate. Each year approximately 1,000 students graduate from the minority elementary schools. However, there are only 2 minority secondary high schools in the region, one in Komotini, where the Turkish minority constitutes half of the population, and the other in Xanthi, where the Turkish minority constitutes 45% of the population. The Greek authorities have not yet responded to the minorities' application to set up new minority schools. The minorities' request to have a brand new premises for the minority secondary high school in Xanthi has not been met either. Lack of enough number of qualified teachers, number of teachers to be assigned by Turkey and Greece to work in each other's minority schools was mutually agreed as 35. Exchange of letters of 1952 and 1955 between the Turkish and Greek foreign ministries, yet, this number was unilaterally reduced by Greece to 16 as of 1990-91 school year. The Greek authorities had not allowed the teachers from Turkey to work at the Turkish minority schools in Xanthi for long years despite the fact that there is no such restriction in the aforementioned letters. The Turkey-educated teachers have not been allowed to work at minority elementary schools since 2002 to 2003 school year either. Restrictions in the field of freedom of religion. Article 11 of the Treaty of Athens, 1913, reads as follows: each mufti will be elected by the Muslim electors in their respective jurisdiction areas. This provision is also repeated in the third protocol annexed to the treaty. In 1920, Greece put into effect the Law No. 2345/1920 for the implementation of the provisions of the Treaty of Athens. In 1990, however, in violation of the provisions of the Treaty of Athens, Greece promulgated a presidential decree which laid out provisions for the appointment of muftis by the governors of the provinces, and the Law No. 2345/1920 was abrogated. Subsequently, not only the Greek authorities appointed muftis against the will of the minority, but also the muftis elected by the minority were subjected to trials and prison sentences. The late Mehmet Aga, who was the former mufti of Xanthi, elected by the Turkish minority of Western Thrace, had been unfairly tried many times and imprisoned. The mufti was sentenced in January 1995 by the Larissa Court of Appeals in Greece to 10 months on charges of usurping the title of mufti, and he was then sent to the Larissa prison. Through the subsequent trials on similar charges, Mehmet Aga was sentenced to 8 years of imprisonment. The Amnesty International declared Mr. Aga as prisoner of conscience in February 24, 1998. In the same vein, on October 21, 1996, Mr. Ibrahim Sarif, Mufti of Komotini, elected in 1990 by members of the Turkish minority, was convicted for usurping the office as he had used the title of Mufti. He was sentenced to 6 months of imprisonment, but was released after appeal. Currently, the elected muftis of Komotini and Xanthi are still not recognized by the Greek government. For the cases brought before the European Court of Human Rights by the elected muftis, there exist 5 decisions by the ECTHR against Greece. The court ruled in 5 different cases that Greece had violated freedom of thought, conscience, and religion, Article 9 of the ECHR, and that in democratic societies, the state does not have the right to interfere with communities' religious leadership. In one case, Greece was also found in violation of the right to a fair trial, Article 6 of the ECHR. Furthermore, the elected muftis of Xanthi and Komotini remain under legal pressure. They are interrogated or sued on grounds that they usurped the office. In 2017, the elected mufti of Xanthi was sentenced to 7-month imprisonment on grounds that he led the funeral prayer of a member of the Turkish minority upon the request of the minority. The sentence was suspended on the condition that he not commit a similar offense within 3 years. Against the will of the Turkish minority, the so-called Law on 240